Welcome to this edition of the Mize Breakroom. My name is Marc Swearengin, your host. I'm Director of Business Development here at Mize. I'm pleased to be joined today with Casale, shareholder here at Mize, along with Tim Shmidl, founder at Prism Financial Group. So today we're going to be talking about estate planning. So Carol, why don't we just jump in? What is estate planning?
Estate planning really is the arrangement of what happens to your assets, and when you're no longer able to determine that, either because you're dead or because you're disabled. And so it's making a plan for their disposition and for the continuity of whatever business or whatever you may have.
How complicated is it to get that started?
It really kind of depends on whether you have vast assets or whether, you're talking about a couple bank accounts and maybe your home. So it varies by degrees.
So kind of getting into that, Tim, then like when you're talking about an estate planning, obviously you've got a lot of documents and little things happen. What does that look like? What does an estate plan portfolio look like?
Yeah, good question. Well, I think, estate plan could consist of just a will, just to help with guardianship and that sort of thing when someone's kind of starting their career. But I think as you work toward a financial level and complexity level within your situation, you'll find that you end up usually with a living trust. That helps avoid probate. It helps with some issues there. A living will is typically a document that's important to have. And think of that as the document, maybe an end-of-life kind of instruction that you might be giving to somebody. Not unusual to also have a power of attorney for both financial and for healthcare directions. The person you want handling your finances are not always the person you want handling your healthcare decisions. Mm-hmm. So those documents, once again, a will does allow you to name guardianship for children, have an executor, and then so really the people that you include in an estate plan are quite important. So really it's those documents that allow you to name that and feel comfortable with who's going to be handling that in the event that Carol describes.
Okay, great. So Carol, what concerns do you have regarding clients' estate planning? What concerns do you have when you're talking to your clients about this topic?
Well, one concern is that maybe they don't have a plan at all, or they have a plan, but it's many years old and they haven't dusted it off and looked at it in quite a while. There have been a number of law changes in the estate area over the last 25 years or so. So older plans might not meet the needs today. So an example would be funding a bypass, what used to be called a bypass trust, and having language in your document that puts as much in the bypass trust as will escape estate tax. Well, today for a couple, that's $26 million or $27 million and change. It might be more than you have, which leaves nothing to your spouse. So there's just a number of reasons why they need to be looked at, updated if need be, and some considerations made. Others are that we know we need to do a plan, but it's we're procrastinating because it's not a fun topic, and but we're you never know when your last day is until it's your last day. So procrastination doesn't make this any easier, and it may make your heir's life or your beneficiary's life much harder if you don't get this done.
Yeah, how difficult is it to have that conversation with clients?
The conversation isn't difficult at the outset, but it becomes difficult when you start giving the client the decisions they need to make. Lots of the decisions that we have to make are, who's going to be my trustee? What happens if my trustee won't or can't serve? For young children, I find for younger people, one of the biggest issues they run into is coming to agreement on who would be guardians for their children. So there's a lot of decision making there that kind of put a roadblock in place to getting things done, it seems.
Yeah, that sounds like a kind of unfun. But are you involved with a lot of those conversations with clients?
Yes, to a great degree. I mean, a lot of them are, you guys need to go hash this out between whether it's your parents, his parents, or none of the above. I can't help you there. I'm not taking your kids.
Yeah.
But
it seems like this is a topic too that most CPA firms probably don't do. But I feel like you've built such a relationship with your clients so you can have these kind of conversations. You're much more of a, in depth with them on all of their financial.
Our relationships with our clients run deeper than just we do your monthly financials or we do your tax return. We We have clients. I mean, I have clients that I've had for 40 years.
That's cool.
And so you know what their situation is, and you can have those kinds of more in-depth conversations. And you understand them better, what their objectives might be.
Mm-hmm. Does it matter what age on that? And sorry to keep that, but the age when start your estate planning when you're talking with some of our clients?
I think you start your estate planning when you have something to worry about, and certainly when you have children.
Mm-hmm.
It's time to be. Those things you need to have those discussions and make those decisions, because again, we don't get to know what's around the corner.
Okay, makes sense.
I think the complexity of the situation is really what expands with the estate planning. But as Carol points out, just having guardianship there for children, to think that if something were to happen to a young couple, and we don't want to leave it up to the courts to decide who might be caring for their children. Certainly the guardianship, having the ability to name those people, and actually several people in line of succession, just to make sure that they feel like the right people are going to be there, because it's really going to be the parenting, and then you've got the financial side with potentially trustees. So
you brought up just a point there. I mean, for people that don't do this, what happens if the court gets involved? Like what is the potential downside if someone doesn't do this and the state gets involved in handling that?
Well, probate is a word that many have heard and have been scared of because of its potential cost, as well as complexity, time frame. And so we really work hard to try to prevent assets flowing through probate. So we can do that in a number of ways. It can be done with beneficiary designations. You might find that with insurance policies or qualified plans such as IRAs. You may find it in titling, certainly living trust. One of the main advantages would be that it would be able to avoid probate. There's other ways to avoid probate, though, as terms of joint titling, adding what's called transfer on death or payable on death kinds of titling types of things. So really just making sure that you've got a place into where your assets would go upon your death. And really probate is just a legal process to determine the home for your assets if you were to pass away without any direction. So really it's a necessary process if there are assets that just don't have the titling needed to do that.
And one of the disadvantages to probate is that information becomes public. So to the extent you want to keep your financial information private, you don't want to go through probate. In terms of a guardianship for children, that wouldn't be the probate court. That would be family court. So let's say couple passes away and both sets of their parents start fighting over who takes the kids. And now you've got a family court trying to sort out what's the best place for your children. So again, it's keeping private your private matters, and it's thinking ahead as to what do you think is the best outcome if you're not here to see something through.
Man, as a parent, that seems like a nightmare situation for me, thinking about that, but that's what you're leaving behind. So getting your affairs in order.
Yes.
So that your family doesn't have to deal with that.
Yes. It's clear to them what your wishes were.
Yes. And I imagine it would also help with, inter-family squabbles, just from, the family's not fighting over who's going to take control or different things. Is that fair?
It is fair.
Yeah.
I think when your assets involve more complex items such as businesses, sometimes you have children or family members in the business, and you have some family members not in the business. How do you go about trying to remedy that situation, making sure you really want them to all benefit from the family's hard work? But as Carol and I like to say, fair does not always mean equal. And taking a look at what kind of efforts have been placed in some of those business interests, it certainly adds complexity to the situation. So it's, but I think I think most of our clients, once they get that document done, they really feel good that they've gotten that done and they can kind of move on. But we try to remind them that it's not a forever document. It needs to be reviewed periodically and just to be kept up with changes in the tax law.
Certainly. So an example would be, I got my documents all done. I've got teenage kids and I had a little money, and, I love my kids and they can do no wrong in my eyes. Maybe they're not teenagers yet. But I set a disposition age for if they inherit from me at 25. Well, 5 years go by and now they're a little closer to 25 and I might be going, oh, wait a minute. I need to change that age.
Yep. Yeah, that makes sense. How about insurance? How does that factor in
Sure.
life insurance on all that?
Yeah, life insurance certainly is an important instrument to have the delivery of dollars at a time when it's needed. I think a lot of people think about that as a young family or to replace someone's income. I think in that case, you just want to make sure your beneficiaries are up to date. Once again, that would avoid probate. Sometimes if there's a passing of both parents with a young family, you'll have what's called a testamentary trust. And it'll be important to have the beneficiary set up to be able to have those dollars go into a trust. And as Carol points out, be there for some age in the future. Mm-hmm. I think there's a second need for life insurance, and it seems to be more of our clients are bringing up these days with the potential change in tax law, and that is life insurance for a estate planning need. And so can think of one client situation where he had quite a bit of life insurance, but it was all owned personally. That was for more the young family type of situation. And so this client was in a tax situation that was going to be subject to estate taxes. So, that couple $1 million of life insurance they had because of the way it was owned was going to be subject to the 40% tax. So, paying $800,000 that wasn't truly necessary was something we were able to help them with. So that second kind of need for insurance is the survivorship kind of insurance. So there's life insurance that's designed to pay a death benefit when an actual estate tax is due. So it aligns itself up at the right time of when taxes typically due. It also, if owned properly, typically by children or in irrevocable trust of some sort, then that death benefit cannot be subject to estate tax. So that's a really quick way to save 40% there. And certainly there are some rules associated with that and make sure that it's funded properly. But life insurance can be a valuable asset, but we need to make sure it's also owned properly and designed in the right method for sure.
Right. So Carol, what considerations when someone has a closely held business as part of their estate?
But there's two considerations, I think. One is, you're going to live for a while, hopefully. Mm-hmm. Do you plan to retire? What do you plan to do with this business? How does it continue after you've decided to do something else? And secondly, if you die with this business, who would be running it, or would it be sold? And so it's really just planning for, again, the disposition of that asset in whatever form. If you wanted to continue in your family, it requires some pretty careful planning. I mean, you can say, no, just sell it and distribute it, the money according to my trust or my estate plan. There's some nuances there. It's not easy to go sell a closely held business. Mm-hmm. But other considerations, no, I want my family to continue to run that. Are they involved today? What is their acumen? Can they do it? So a lot to think about when you're trying to leave a legacy like a business to carry on for generations in terms of estate planning and just succession, retirement, other kinds of planning.
So if you left the business to someone, does that person necessarily have to run the business?
No.
Okay.
Not necessarily. I mean, it depends on the business. You may have some contractual obligations that we deal with a lot of franchise restaurants. Their franchises are going to govern who can be owning an entity that owns one of the franchises. Mm-hmm. But you hopefully are leaving it to somebody or turning it over to somebody who's bright enough, if they can't run it, to get somebody in place who can.
Yeah. Why you should be revisiting it over time, too.
Yes. Yeah. The capabilities of those that are supposed to step in are important. Yeah. And their interest in doing so.
Mm-hmm. What about non-business considerations on drafting an estate plan?
Sure. Well, and we need an estate planning attorney to actually draw up the actual documents. We can help provide conceptual advice and recognize opportunities where somebody needs to get some additional planning. And so we work closely with many estate planning attorneys to get that done. I think when somebody's looking at the non-business side, it tends to be more the people side of things. So, I think once again, exploring those documents, when you have a will, you have an executrix that will actually be in charge of making sure that will is followed. You may have guardians that come in to play that will help with the care of children while they're minors. When you move to a trust, you'll typically have a trustee and probably multiple trustees in terms of, and a trustee is actually the one that's in charge of the financial side of the assets. So that person doesn't necessarily need to have a real strong financial background. They just need to be able to care about your family, making sure that those goals are accomplished that you'd set out, and have the ability to go hire somebody to help them with the specifics, where it's the accounting side, financial planning, investment type of work. And it's not unusual. I think our preference is probably individual trustees. If you can find somebody that truly does meet the needs for your family, but it's typical that we would end up with a corporate trustee just to make sure that if there are a couple individual trustees or family members or friends that can't act, that you can have a corporate trustee step in and be there to make sure that those long-term needs might be taken care of.
Mm-hmm.
As I mentioned, the healthcare directives, the non-business side, once again, really looking at your healthcare directives, and this is somebody that you're going to be putting potentially a tough decision in front of them someday. So certainly you want them to be aware of your circumstances, and certainly family members are typically who you'd find in that position, as well as the financial power of attorneys. As I mentioned before, not always the same person as you want healthcare directives, but certainly those are the people that are going to be involved in that.
Okay, great. Will you tell me about, there's a sunset provision from the 2017 Tax Act? Can you tell me a little bit about that and
Sure.
the impacts of those that people are going to be seeing?
Sure. Well, today, a couple has an exclusion amount of over $27 million between them. $13,661,000 or something like that, individually. Next year, we anticipate, because it's inflation indexed, it will go up to about $28 million or $14 million apiece. The 2017 Tax Act, because of the budgetary requirements of tax legislation, that it's revenue neutral, has sunset provisions, which means those neat rules we have, they end. And so if nothing changes from current law, then in January of 2026, we revert back to prior law, and those amounts drop about in half. So you go from individually having a 14 million exclusion to somewhere around 7. Again, they're indexed for inflation. It's not an exact math. So people with estates, obviously with that 28 million or more, but even between the 14 million, if you're a couple, and the 28 million, those are going to be exposed to tax if this law sunsets than they weren't before. And the tax rate's 40% at that level. So do you do some planning now, to the extent you can? Gifting, bringing in trust it can become quite complex. You have to decide if, this isn't your tax. This tax gets paid at your death. Well, okay. Some people are they're fine. No, my kids will just get less. I'm not doing all that. But if you want to leave, if you don't want that to happen, then you want to put these things in place to the extent you can prior to December 31st, 2025. And if you're having a business or some more complex assets, this takes time. So you can't wait until December 1, 2025 and start putting this plan in place. You'll never get it done in time.
So for those things, and Tim had mentioned earlier just about things, needing an attorney, all that, should they just come right to, their financial advisor, their accountant? Whom should they talk to about
They could talk
things?
to me. They could talk to Tim just to get the ball rolling. Ultimately, we're going to be talking to an attorney, but we can certainly get the thought process started as to, here's some things to consider.
And I think planning opportunities as it relates to that could be several. I think one thing we typically will look at is annual gifting. For example, this year, a person can give away $18,000 to whomever they want without any gift tax to the recipient or the donor, and really without any actual paperwork. Certainly, a person can give away more than that if they want to, and use up part of their exclusion. We also find that charitable gifting can be quite effective in reducing estate tax. So once again, in an estate that might be subject to typical estate tax, any money given to charity is not subject to that 40% tax. So, we don't want to assume anything, but if somebody's been actively charitable during their working years, then that may be a real nice opportunity to have them be a part of the estate plan.
Yes. I mean, it's a way to make sure you have access to your assets during your life, because again, we don't get to see around the corner, but then providing for an estate or a charity as some portion of your estate, should there be money there at your death.
So really, from a financial planning perspective, I think what we really seem to spend a lot of time on are gathering a list of someone's assets today, taking a look at the income taxation of them. Once again, are they in a trust? Are they in a Roth IRA? Ideally, if they're in a traditional IRA, and really doing a projection. So we can take a look at what their spending needs might be. We can take a look at inflation, obviously a rate of return on their earnings, and we can assist them with what their financial future might look like, and then go in and assess what the estate tax situation might be. Once again, visit with a client the other day, about 80% of her estate was planning to go to charity. So that was something where it was a significant estate, but yet it really wasn't going to result in an estate tax situation because of the goals there and the final beneficiary. So I think the planning side can really help with anticipating what that tax might be. And then once again, their personal circumstances, really seeing whether we need to be doing something about that today. Because Carol and I have worked with an estate planning attorney quite some time, and their comment is always, you need to be as comfortable after a gift as you were before making the gift. So, gifting is kind of secondary, in my opinion, after you make sure your own goals can be accomplished, because you just don't want to be in an uncomfortable financial situation because you let the estate tax tail wag the dog. We really need to make sure someone's needs are going to be taken care of, and really plan for the next generation there after the fact.
Yeah. That's a really good comment. It's when you're talking to somebody about their estate plan, their first obligation is to make sure they and their spouse, if they're married, or have what they need for their lifetime. Don't start giving it away until you know that.
Yeah, it seems like a great point that maybe, again, being their partner in them to understand their needs and not just do a plan just for the sake of a plan. But making sure that plan's actually achieving some goals that you want, even for yourself. Because to your point, you made this earlier, this is, you've got a long time to go. So make sure that you're not, that you're taking care of yourself in the meantime.
Well, I think Carol brought up a great point in that, we need an estate planning attorney eventually to complete the documents and assist us with the planning. I know our knowledge of a client's situation, sometimes it's their family, sometimes it's their financial side, that when we enter a meeting, we'll typically attend those meetings with our clients, because we can really provide that introductory comment. We can share the net worth, we can share the financial situation, and really sit on the side of the client, I think, in terms of going through that discussion. We might have been through that hundreds of times in our career, and for our clients, this might be literally the first, second, or third time they've sat down with an estate planning attorney talking about these kinds of things. So I think having them feel a little more comfortable that we're there to help them through that process, and once again, are truly as a fiduciary on looking out for their family's future, for sure.
And bringing the understanding of their business, if there is a business involved. Clients may or may not know all of the intricacies of how they're structured and what type of entity, and but we do. So it's helpful for the attorney to understand whether we're talking about corporate stock, partnership interests, those kinds of things, because they get treated differently under the estate rules.
So if someone wanted to get started, I mean, there are people watching this, listening to this, what should be their kind of first steps? When you a call, should they call, contact an attorney first? What would be the logical first thing for someone who's listening to this and realizing that, yes, they need to be doing that?
So they call and say, I need to work on my estate plan. Well, my first question is going to be, do you have something in place?
Mm-hmm.
And if the answer is yes, I'm going to be, well, dust it off, send me a copy. Let's read it and see what it says and what do we need to start from scratch, or is the bulk of this something that we can transfer to a new document or just update this document?
Mm-hmm.
If there's nothing in place, then we're typically going to, I'm working with this, you're going to have to find an attorney,
Mm-hmm.
and they usually have questionnaires. And so maybe I'll ask the attorney, send me your questionnaire and I can modify it for my client because I know my client, and get started that way.
Mm-hmm.
because it's, again, it depends on where you're at in your life. If they're younger, it's okay. Well, have you thought about who would be guardians for your children? And do you at least have a basic will? Because an estate plan can take several months, in some cases, several years to get. But if you've got young children, I'm going to push them to get a will in place, just if nothing else, to deal with who might be a guardian for their children while we're working through the rest of the nuances of an estate plan.
Covered a lot on this topic. Anything else that you think that we might have, that the folks listening here might take away? But it sounds like we covered quite a bit of the topics of estate planning today.
Yeah, I think Carol, just to add to Carol's comments on the sunsetting.
Mm-hmm.
Okay.
I think we talk about high net worth people and maybe those starting their careers, middle of their careers. But, a high net worth individual, I would say, is somebody that's worth $5 million or more. Certainly you've got ultra high net worth that go beyond that. But the estate planning techniques that are available to take care of your family, assist with tax reduction where possible, this sunsetting is going to be a planning opportunity. We'll probably learn a little bit more in the election on to which direction that might go. But once again, that's planning on sunsetting. So it takes no action by Washington to have a revert to the old rules. So I think we need to plan with the idea that that's probably what's going to be in play.
Mm-hmm.
So I think for those individuals that would be in that next level of net worth, that 10 million or more, they definitely need to be reviewing their current plan, looking at their current assets, seeing if there are planning opportunities that help meet their goals, as well as assist in the reduction of taxes, because 40% of a big number is still a big number. So we need to make that a priority. And so I think the time is probably now to begin that.
To begin thinking. And yeah, I mean, that's unfortunately no action in Washington seems to be the new norm. So even if the elections go the way you want them, I mean, who knows? Because as long as we have this divided of a legislature, a Congress, we're not getting legislation passed.
Mm-hmm.
So it's pretty difficult. Even it'd be hard to say. I'm not predicting, but things aren't looking good for meaningful change.
I agree with that. Well, Carol, Tim, thank you so much again for sharing this information for everyone today. We appreciate it. If anyone has any questions, you can go to MizeCPAs.com, find information. You can always reach out to Carol, Tim at prismfg.com. Also, if you want information, you can send an email to breakroom@MizeCPAs.com, and we'll make sure that we get any questions answered and introduce you if you need to. Again, thank you guys for joining. Really appreciate talking with you guys today. And all right. Thanks for listening to another episode of the Mize Breakroom. If you watch this episode on YouTube, please like and subscribe so you never miss another episode. You can find the Mize Breakroom anywhere you can find podcasts. If you like what you heard, please rate and review the podcast 5 stars. Looking for more information? You can find us on most social media platforms at Mize CPAs. Thanks for listening, and see you next time in the Breakroom. The Mize Breakroom is produced by Mize CPAs and hosted by Marc Swearengin. Mize CPAs is not a law firm and does not provide legal advice. The information shared in this podcast is for general information purposes only and is not intended to constitute legal or technical accounting, tax, consulting, and/or professional advice that may apply to your specific business. The listener is encouraged to consult counsel and/or their accountant before making decisions or taking any action concerning the matters in this communication to address the recipient's particular facts, circumstances, position, business considerations, or other unique relevant matters, as well as to evaluate any applicable federal, state, or local laws.